this is Brigitte again with HGU, and now we will be discussing paragraphs 25 through 29 of the 8.0 contract. So paragraph 25 is business days and hours. Business days are Monday through Friday, excluding federal holidays, and business hours are 8 a.m. to 6 p.m. Chicago time. Now, here's a fun fact. We tell all of you, buyers and sellers, that we have a deadline of 5 p.m. We don't do that to be mean, but we do that for our own sanity and for yours a little bit, so that we're not scrambling at the last minute. If you get back to us at 4:55, we're not worried about whether our email is sent to the other side within those 6 minutes. So, and also likelihood is that if we don't hear from you by 4:45, we'll probably be drafting up an extension request, so that in the event we do not hear from you, we will reserve your rights, send that extension, and then be able to discuss with you that next business day. So if a closing or loan contingency date does not fall on a business day, it defaults to the next day. Paragraph 26, electronic or digital signatures. So electronic or digital signatures are sufficient for signing and amending the contract. An electronic signature would be a facsimile, which is an original hand-signed document and email. A digital signature would be DocuSign or the like. Paragraph 27, direction to escrowee. So here we are talking about the instance where the contract is terminated by one party or the other. So I'm going to scroll down here so that you can see this entire paragraph in the screen. And so joint written direction is needed for the release of earnest money. Alternatively, you need a court order, right? So going back to the joint written direction, both the buyer and the seller must sign that release saying that the buyer or the earnest money is going all to the buyer, all to the seller, whatever combination of the two, but the parties need to agree. In the event that neither of those two scenarios take place, so we don't have joint written direction and we don't have a court order, we can do one of the following two things. So if your agent is holding the earnest money, if it's held by a licensed Illinois real estate brokerage, they can provide notice of intended disbursement. So basically 14 days prior to the date of intended disbursement, they say, hey, we're planning on dispersing the earnest money funds 100% to seller, none to buyer. And unless objection in writing is received prior to that date, then they can go ahead with that. If objection is received in writing, then you still gotta hold the earnest money until we have joint written direction or a court order. The other option is that the person or company holding the escrow or the earnest money can file an interpleader action with the court. So basically, the court would determine where the money belongs. And the escrowee gets reimbursed for court costs and reasonable attorney fees. And if the amount held in escrow is not sufficient to reimburse the escrowee, then the buyer and the seller will split the fees and costs associated with the action. So next we have paragraph 28, and this is going to be split. So I'll keep it on the upper half. So this is notice. So it just talks about all the means of notice that are sufficient under the contract. So we have personal delivery, we have snail mail, either certified or regular, fax, email, commercial overnight delivery, for example, FedEx, and that is it. Best practices here would, of course, be to include your agents, to the buyer, the listing agent, and the buyer's agent on all correspondence. So then we have paragraph 29. So time is of the essence, right? So that means timing is material in performance of the contract. Most real estate disputes don't result in litigation, but when they do, there is a prevailing party provision. And that is that the prevailing party, so the party that wins in court, can collect reasonable attorney's fees and costs from the other party. All right, so that is all I have for you at this time. I will be back shortly, and you take care.